Lord Sumption, Jonathan Sumption, was a Supreme Court Justice between 2012 and 2018. I asked what he made of the judgment.
There's no surprise in it. The Scotland Act is absolutely clear, and the answer has always been obvious. A referendum has got to be authorised by some legislation, by the Scottish Parliament, for example. The Scottish Parliament has very limited powers in relation to the UK Constitution, and it cannot deal with reserved matters, and those include matters relating to the Union of England and Scotland and to the status of the Westminster Parliament in Scotland. It seems perfectly obvious that an act of the Scottish Parliament authorising a referendum on independence would relate to the Union of England and Scotland. It would extinguish it. It seems equally obvious that it would relate to the status of the Westminster Parliament in Scotland. And the Scottish Government argued that Indyref II didn't really relate to these matters because it would only be advisory. It wouldn't have any direct legal effect on the Union. But the problem about that is that the Scotland Act requires the court to look at the practical effect as well as the legal effect of a proposed Scottish bill.
If it was so obvious, then why have we been through all this?
Well, that's a good question. And Mrs. Sturgeon is a very shrewd politician. And this is a political manoeuvre. It enables her to blame everyone other than herself for not having a referendum. She's had plenty of legal advice. It's obvious that her own Lord Advocate, her top law officer, had no confidence in her own argument. And I think the explanation is perfectly simple. She doesn't want a referendum at the moment because she couldn't be sure of winning it. But she's under pressure from her less realistic followers, and she would prefer to be stopped from having her referendum by Westminster than by her own innate caution. I mean, what was actually particularly interesting was and rather unexpected, at least by me, was that the Supreme Court took some care to dismiss the arguments separately put by the Scottish National Party, her party, about independence, because they had run a separate argument that the Scotland Act ought to be interpreted in a way consistent with the right of Scotland to self-determination in international law. And the Supreme Court responded that Scotland doesn't have a right of self-determination.
At what point could the courts get involved? And I'm thinking what we may now be in a situation where there's a general election, but the Scottish First Minister makes it a single issue vote on whether Scotland should be independent.
Well, the trouble is she can't do that. I mean, legally she can do it, but people vote in general elections for all sorts of different reasons. And Mrs. Sturgeon can't control the reasons for which people vote either for or against her party.
Indeed, but so that's interesting. Legally she can do it. There's nothing to stop her doing it. It's just whether people choose to do it or not.
Yes, I mean, the trouble is general elections are big messes. They have a large number of issues. People vote for all sorts of different reasons. And to say this result means that people were in favour of that specific policy is always very difficult to do.
If the Westminster government is still holding out not holding a referendum, the Supreme Court will still say, look, nothing's changed.
The Supreme Court is not a political court. It's not passing judgment on the rightness or wrongness of Westminster's refusal to allow a Scottish referendum. It's simply talking about the law. They could change their mind if the law changed, if the Scotland Act was amended. But if in 10 years' time the Scotland Act says exactly the same as it does today, then they're going to say that it means exactly the same. The Supreme Court, like other courts, frequently has to make decisions which have political implications. That doesn't mean to say that those are political decisions.